And I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Snyman II. I'm the natural person, I'm the living man. How we doing today, Miss Braley?
We are upright, if nothing else. So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person, the living.
Buckle up. Guys, today, we're watching the moment the script officially starts. The court opens normally, professionally, and with patience. Then the defendant introduces himself not just as a name, but as a living man, instantly signaling what's coming. This is the sovereign citizen opener. Reject the legal identity, elevate the natural person, and hope the court collapses under wordplay. The magistrate stays calm, grounded, and focused on procedure, while the defendant tries to control the frame of the interaction. Right here, the tone is set. One side is operating in reality, the other in internet mythology. This early contrast matters because it shows the court isn't confused. It's simply allowing the rope to be unspooled.
Recalling case number 19S00472. That is the state of Michigan versus Thomas Ulrich Styron, the second, you said. And also calling 24W001025. That is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. Is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. And I'm not, me being a living person, I don't, my name is in proper punctuation. I don't have a all caps name, nor.
Okay, I'm going to cut you off right there. Okay.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering.
The defendant insists the name on the case is a fictional entity, not him. This is a recycled sovereign tactic meant to sever accountability. The problem? Courts don't operate on metaphysical identity theories. They operate on jurisdiction, presence, and conduct. The magistrate doesn't argue philosophy. She anchors everything to the record. This is crucial. Courts win by refusing to debate fantasy. Every second, the defendant spends rejecting his own name is a second he's still physically present, on record, and subject to the process. This isn't clever. It's self-sabotage wrapped in confidence.
Continue to wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not.
The defendant treats jurisdiction like a magic spell that must be proven on demand. The court responds with something devastatingly simple. You're here in Michigan, charged under Michigan law. That's it. Jurisdiction isn't a contract you negotiate. It's a legal condition that already exists. The more he insists it's missing, the clearer it becomes that he doesn't grasp how it's established. This exchange quietly dismantles the entire sovereign premise without theater.
Charged with is operating a motor vehicle without having a license on your person. So, I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I'm I was traveling home.
Okay.
I wasn't doing business at all. And also, from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
At this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity?
I hear you, and at this point you are appearing in front of the court. You have put your name on the record, and yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that...
He claims canceling his license somehow places him outside regulation. That's like tearing up your library card and insisting books are now illegal to read. The magistrate repeatedly clarifies she's not asking for agreement, only understanding. This is a legal checkpoint, and he keeps trying to reroute into ideology. Ironically, his refusal to answer cleanly only tightens the procedural net. Silence, confusion, and deflection don't weaken charges. They streamline the court's next steps.
At your pre-trial date, which is going to be June 26th.
So the documentation that I have published, recorded in with... excuse me, sorry. The documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case, that's... I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records. Is that good enough?
Whatever documentation you have,
Mm-hmm.
bring it with you to your pre-trial date. That is what I am telling you, yes. So. And again, that court date, June 26th? Okay. Will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with...
The defendant insists licenses only apply to commerce, not personal travel. Courts have crushed this argument for decades, and the magistrate doesn't even entertain it. She labels it incorrect and moves on. That's power. Notice how the law doesn't feel the need to relitigate settled reality for every YouTube graduate. The charge stands, the penalties are stated, and the record is clean. At this moment, belief collides with precedent, and belief loses every time.
Court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay? So, at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there under threat.
This is where sovereign citizens misunderstand process itself. Courts don't pause hearings to satisfy personal theories. Jurisdiction isn't voted on. It's asserted by law and affirmed by participation. The defendant keeps talking, but procedurally he's already in. By speaking, identifying himself, and engaging, he reinforces the very authority he's trying to deny. The irony is brutal. The more he resists, the more he confirms the court's power. This isn't resistance, it's cooperation in disguise.